Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. You know, I get comments and questions about litigation every week, and one that arises often concerns discovery. Like this commenter. Well, the truth is, the defendant can request any information he or she deems is necessary to defend their case. However, it does not mean they are entitled to it. And that is what we're going to discuss in this video. When the defendant is not entitled to discovery requests. And we're going to look at 6 times when the court will deny the defendant's request. So let's get started. Number 1, privileged information. It is confidential communications or materials protected by law from disclosure during legal proceedings, allowing a party to refuse discovery requests. For example, the attorney-client privilege. The attorney-client privilege is confidential communications between a client and their attorney for the purpose of obtaining legal advice. Another example of privileged information, the attorney work product. The attorney work product includes materials prepared by an attorney, in this case, pro se, you're your own attorney, in anticipation of litigation. Another example of privileged information is the spousal privilege. It consists of confidential communications made between spouses during marriage. Another example is the doctor-patient privilege. It includes confidential information acquired by a doctor or therapist from a patient during treatment. Another example of privileged information is the self-incrimination privilege. It includes protection against disclosing information that could lead to criminal liability. For example, the right to remain silent, which is a Fifth Amendment privilege, is a valid objection to producing discovery in civil cases. Now, please understand that even though one may assert their Fifth Amendment right, it could still look bad for the individual. But you just need to understand that it is a right. And the last example I want to show you is the clergy penitent privilege. It includes confidential communications made to a religious advisor in their professional capacity. The second time when defendant may be denied discovery, undue burden or cost. The plaintiff must show that access to the material is not reasonable. Electronically stored information is sometimes difficult to get access to. Sometimes the issue is non-access to the computer. However, The public library have computers that the public can use. Courthouse has libraries that the public can use. And law schools have a library that they often let the public use. Operating the computer. If you don't know how to operate the computer, ask. Someone will help you. Then there's the issue of cost of printing. Here's my point. If any of these would be an issue for you, make sure that you convey this to whoever you are speaking with. Okay? Open your mouth, okay? A third time when defendant may be denied the request. Irrelevant documents. And I want to touch upon private social media photos. So while the plaintiff is required to disclose documents that are relevant to the claims, private social media photos potentially may not be disclosed, but the plaintiff must be able to show that the photos are unrelated to the claim and that the photos have no bearing on the case. Number 3, already known and possessed documents. And what are we talking about? We're talking about documents that have already been provided to the defendant or are known to be in the defendant's possession. But remember I said to read the local rules, because in some jurisdictions I've seen where this would not be true. A fifth instance when defendant's request may be denied. Exempt proceedings. Federal Rules of Civil Procedure 26A 1B includes a list of these exemptions, and this link here should be clickable. And number 6, court protective orders. The court may issue a protective order to prevent the disclosure of certain information, such as sensitive information, trade secrets, your PSI or your personal identifying information. The disclosure of these things could cause a person harm in many, many ways. So, if you believe that your information plaintiff falls under these categories, you have the right to file a motion asking the court to issue a protective order. But make sure that your protest is legitimate. Read Federal Rules of Civil Procedure 26C. Okay, plaintiff, make sure that you read the Federal Rules of Civil Procedure on each issue. And remember to read the local rules. Okay? I'm Advocate Lucinda, and until next time, be M.